We strive to bring our support group members the best of the best when we have a guest speaker. Today, we are honored once again to have Attorney William Johnson here with us. William Johnson has his BA from the University of Florida Liberal Arts and Sciences College. He has his JD from the University of Florida College of Law. He is Florida Bar Board certified in the areas of elder law since 2004 and practices predominantly in the fields of estate planning, Medicaid planning, long-term care planning, guardianship, incapacity planning, will and trust litigation, and probate. He is a two-time winner of the Elder Law Section Member of the Year Award. Mr. Johnson belongs to the National Academy of Elder Law Attorneys, the Academy of Florida Elder Law Attorneys, the Space Coast Guardianship Association, and is the president of the Space Coast chapter of the Florida State Guardianship Association. He has been generous with his time and contributions to local organizations. He was the past chairman of the board of directors for the Brevard Alzheimer's Foundation and was the past president of the Brevard Association of Human Services. We all know how difficult this journey of dementia can be to navigate. We need to educate and prepare from a legal standpoint. So let's listen in and learn a bit about some legal advice that might help us in some situations. Grab a pencil and a paper, take some notes, hold those questions until the end, and I promise you we'll have time to answer them. If we run a little bit over and you need to leave, please simply just sign off. Right now, I'm going to hand the meeting over to Mr. Johnson. Thank you for being here.
Thank you, Sherry. First thing I'm going to tell you is I have a website. It's called floridaelderlaw.net, all spelled out. If you go there, you can download a copy. Let's see if I can get it there. I'll have to adjust my camera, but I have a little book. It's called the Florida Long-Term Care and Nursing Home Answer Book. And in the very back of this book, I talk about all the legal documents that deal with incapacity. I talk about guardianship. I talk about Medicaid, VA benefits, how to get good care, all that kind of stuff. And you can download it right off our website. So in dealing with folks who have dementia, usually I get them they come in the office, either their loved one or their loved one and the patient. And you know, the biggest question is, what documents do we need to start preparing for or have in place? And number one, usually on the list, is the durable power of attorney. Now, durable powers of attorney in Florida are tricky. And I can tell you, I had a lady come in. She's a single lady, has no kids. She has a brother who she's named in her power of attorney. She is looking at qualifying for Medicaid if she were to have a long-term care event. She doesn't have any illnesses, and she has a durable power of attorney that she got off of one of the online services. Her income exceeds the Medicaid income cap, and subsequently, whoever her power of attorney is would need the power to create something called an income cap trust. Well, her power of attorney, done by one of these big companies that advertises on TV, does not have the language in it to create that trust. So it was defective, meaning if something happened to her and her brother had to try and get her Medicaid, he would have to end up doing a guardianship to get the power to create that trust. So the moral of the story is, one, is you only have the powers that you are given in the power of attorney. And I find most people never read the document. They just go to the lawyer's office, get a document called durable power of attorney, and they think they're covered. You have to look at the powers that you are given. So if you need to get into your loved one's 401k to help pay for your care, it better say that in the power of attorney. Okay, if you need to get cash value out of the life insurance policy to get them below 2,000 to qualify them for Medicaid, it better say you can do that in the power of attorney. And a lot of things are not in these power of attorneys, even the ones prepared by attorneys. We noticed some very glaring errors. And in fact, we will call the attorney's offices up and send them our form. I'd rather have them copy our form and get something done right than have these people just hanging out there. Also, if you moved here from another state, Florida, the way we interpret the documents is a lot different than a lot of states. In New York, Illinois, and some other states, they have what they call a statutory power of attorney. And sometimes these things are only 2 pages long and you just check the box off. In Florida, you specifically have to give somebody a power or they do not have it. So checking a box that says real estate transactions does not work in Florida. Okay, so if you have one of these from out of state, you need to redo it. Sometimes people come in the office, they have these documents that they got this form that hasn't been updated since the 90s from Office Depot or some other company that sells the forms, some office supply place. And, you know, and they think they're covered again, but they are not. In Florida, we need the signature, 2 witnesses, and a notarization. To sign any sort of legal documents, you need to record the durable power of attorney with the clerk of court prior to executing those legal documents. Why do we require 2 witnesses and a notary? Because to record a document in Florida, you have to have 2 witnesses and a notary. One of the witnesses could also be the notary, because the notary is not authenticating their own signature. They're only authenticating the signature of the person signing the document. If and when you are signing somebody up for nursing home care or assisted living care, if you are the agent, make sure when you sign your name, if the patient cannot sign their name, make sure you sign your name and put DPOA or durable power of attorney or agent on that paperwork, because that makes it so that you are not liable for the patient's bill. Okay. Now, under federal law, a nursing home cannot make somebody, as a condition for admitting someone, have a third party forced to be liable for the bill. That is not true for assisted livings. There is no federal statute that governs them, and assisted living facilities will have somewhere in their documentation something about you having to be responsible for paying the bill of the person. Okay. Another big tip that you may not know: in Florida, you are not liable for your spouse's debts unless you agree to be liable for them. Okay. So, and the famous case was a gentleman had a $200,000 hospital bill. He admitted himself into the hospital, and the hospital tried to sue his wife after he died. They lost because it's not her bill. She wasn't liable for it. So make sure you don't take on any personal liability when you're signing documents as an agent. Make sure you read all the documents. Another tip is a lot of facilities now present you the document on an iPad. It's not even a paper document, and you have to literally check off a box before you can even go to the next page. So meaning you have to agree to everything that's in the document. If that happens, tell them you wanted a printed copy so you can take it home and read it. You don't have to sign somebody up by iPad if they're going into an assisted living or a nursing home. That's kind of crazy. There's no chance that you'll ever read all the fine print as they're sitting there trying to scroll through that. So durable power of attorney is the best of all documents. It's also the worst of all documents, because if you name somebody that is untrustworthy, you've basically given them the keys to your financial kingdom. And that is the number one probably tool of exploiters out there. And if you're probably on this call, you're not one of those people. I've met them, and they could really care less about the care of the individuals. They're just out for the money. So if you're on this call, you're probably not a person who falls into that category. Also, in 2011, there was a law change. Certain types of clauses in a durable power of attorney have to be signed off, either initialed or signatures right next to the clause. And most of those deal with making gifts or creating a trust or changing beneficiary designations. I would urge you to check off all those things and sign off on all of those, because most of those things are what we have to use if we have to get somebody qualified for Medicaid, especially. You know, you don't want to get somebody qualified for Medicaid and then the caregiver passes away and leaves all the money to them, and then we have to do the whole procedure all over again. So that is some of the tips. And it should be a durable power of attorney, a good one, should be somewhere at least 10 pages long, if not more, in Florida, because it's going to be pages and pages and pages of boilerplate, because we specifically have to give all these powers to the agent. So it's a broad grant of authority, basically, to manage anything financial or do anything financial on behalf of the person. So, and because we have to be specific, the document ends up being pages and pages of boilerplate, but it should be a fairly lengthy document. If you have a 1 or 2 pager, it's probably not a good one. You know, and a broad grant of authority, such as to do anything I could do personally, doesn't work in Florida. It has to be a specific grant. The next document, and by the way, powers of attorney in Florida are effective upon signing. So if you have one of these, once you sign it, that person can go out and access your finances. So generally, if you're doing one of these ahead of time, we tell you not to give it to anybody until they absolutely need it. Put it somewhere where they can get to it, but don't be handing it out, because it can be such a dangerous document. The next document is the designation of healthcare surrogate. That is who would make your healthcare decisions if you are unable to. Once a doctor notes in your medical file that you are unable to give informed consent, the person named in the healthcare surrogate will take over making the decisions. Now, the practicality of that, when do doctors actually note in the medical record that somebody can't give informed consent, is probably pretty rare. Generally, doctors don't like to put those kinds of statements unless you request it in the medical file. The healthcare surrogate should also have some sort of HIPAA release language. So if you're unable to make medical decisions, the doctors determine that, then the person named in the document will take over making decisions for you. And we want that person to be able to access your medical file. That's where the HIPAA release becomes important, because they will need that to get into the medical file. It either needs to be in the healthcare surrogate document itself. Ours says my healthcare surrogate is my designated representatives for purposes of HIPAA, or you can have a separate HIPAA release, or even most doctors' offices and the hospitals have you fill out a HIPAA release, which gives them access to the medical records. A healthcare surrogate, the person named, must follow your wishes if they know what they are, what we call substituted judgment. And if they don't know what your wishes are, they have to use a best interest standard. So acting your best interest. So if you're doing one of these documents ahead of time, you may want to pull in the document if you have any specific medical wishes. I have had people say they don't want blood transfusions. They don't ever want to be in a nursing home, and they put that in the document. And obviously, then the healthcare surrogate certainly knows what their wishes are with regard to these issues. The third document that we talk about is the living will. The living will is a document wherein you state what your end of life wishes are. And if you are incapacitated and either in a terminal condition, an end stage condition, or a persistent vegetative state, whether or not you want life support continued, if that is only prolonging the dying process. And then you also indicate whether or not you want the artificial administration of food and water, basically a feeding tube, if it's just going to prolong the dying process. And you indicate on there what your wishes are. And then the medical provider, either your doctor or the hospital, will follow what you put there. Great question I usually get asked is, what if my healthcare surrogate wants to keep me going? And what if my living will says to discontinue life support? Who wins out? Well, the living will wins out. There was a case out of Orlando where the hospital asked the court to decide that question. And the living will obviously is a statement of what your wishes are. And your healthcare surrogate actually should have to follow that statement of wishes. So the living will does override anything the healthcare surrogate does. Now, if you don't have a healthcare surrogate, we do have a healthcare proxy statute. And that statute has a pecking order of who will make your healthcare decisions. Starts off with your guardian, then it goes to your healthcare surrogate, then spouse, then a majority of your adult children, I think then your parents, and then your siblings, your next closest relative, your next best friend, and then a social worker who is independent from the hospital. So you could have a situation where you would have multiple children who disagree about everything, trying to make your healthcare decisions, if you have not spelled out who is going to be the decision maker in a document such as a healthcare surrogate. Now, if you don't have these documents, or it's too late for you to execute these documents, then what we have to do is something called a guardianship. And the way a guardianship works is we file 2 petitions with the court system. The first petition is to determine whether or not you're incapacitated, and the second petition is to appoint a guardian. When you file the petition for incapacity, the court appoints a 3-member examining committee and an attorney to represent you. And then the examining committee goes out, examines the individual, and reports back to the court whether the person's partially, totally, or not at all incapacitated. And if they are partially or totally incapacitated, usually we move on to the appointment of a guardian. Now, if two or more people have filed for guardianship, then we have to have a trial to determine who is the better of the competing petitions to be appointed. Best to just avoid that whole situation, have the documents. I'm doing one. I did a contested guardianship that went on for years into the hundreds of thousands of dollars in attorney's fees. There is a document where you can spell out to the court who you want to be your guardian. It's called a pre-need guardian declaration. And in that document, you tell the court, if a guardianship gets filed, this is who I want to be my guardian. And that creates a presumption in favor of that person. That is a rebuttable presumption, meaning if if I name my son and I want him to be my guardian, and by the time the guardianship gets filed, my son's got a felony conviction, well, guess what? Even though I named him to be my guardian, he's not going to be my guardian. So usually it's the same people you name, the power of attorney, healthcare surrogate, and the pre-need guardian, which kind of makes the document, if your power of attorney is stealing from you or misappropriating your funds, then even though you might have named them in the pre-need guardian, we'll probably skip over that person if that can be proved in court. The question I get a lot is, when can we sign these documents? I get some people who think just because a doctor said somebody has dementia that they can't have their loved one come in and do these documents. That's not necessarily true. Now, dementia, in my experience, is varying shades of gray. It's usually never black or white. And so we really have to look at whether the person has a period of lucidity where they can tell me who they want to be in these various positions. The power of attorney, generally, they have to know how that the duties and powers they're giving to this person, what the effect of doing that is, and understand the nature of contracting, because that's a big power that you're giving. And they could make them liable if your agent does something that can make you liable for. For a healthcare surrogate, generally, the standard is the ability to give informed consent. If they have the ability to give informed consent, they probably can execute a healthcare surrogate, because that's really what we're talking about with that document. So when can they come in? And also, as far as attorneys go, if you're giving the power of attorney and healthcare surrogate to your spouse, we're not so leery about that, especially if you've been married 30 years or something like that. If you are giving it to one of your 8 kids, all of which don't get along, and the one kid who drove you to my office is the one you want to name in the documents, then we get a little more cautious. And these documents become very important in the event you have an extended family. So 50% of people over age 65 have an extended family, meaning they are in a second marriage with kids from a prior marriage, okay, or their spouse has kids. So that can create a little problem. Is your new spouse going to make these decisions for you, or are your kids going to make these decisions? Okay. And, if there erupts a fight, usually that gets played out in guardianship court. That's why we try to flesh out all the problems ahead of time to make sure that we got most of the bases covered. So there, when you're in a second marriage situation, second or subsequent for some people, you want to make sure you have these documents placed to make sure who these decision makers are and that your wishes are going to be followed. And I think that puts me right at 25 minutes, or 28. Do you want to open it up for a question and answer?